Ladies and gentlemen, dear friends and supporters of the Käte Hamburger Center Law as Culture, and new friends from the law and language scientific community, welcome at our center. Let me first welcome all of you in the name of the direction of Nina Detloff, of Clemens Albrecht, and myself. The workshop is due, in a way, to former fellow Larry Solon, here present, if I see right, who has made this extraordinary gathering of specialists in juristic linguistics possible. Many thanks for being with us, dear Larry, and for having brought this wonderful crowd together. No applause, why not? Okay. Allow me to start, yes. Allow me to start with a somehow fundamental issue that may at the same time cast some light on the following question. Why might the traditional problem of law and language take a new turn when it's related to the law as culture project? A project pretentious enough to have labeled itself a paradigm. What is new, in other words, when we relate law and language with reference to culture? Let me try to give you an idea of why conceiving law as culture makes a difference when looking at the problematic nature of law and language. First of all, it affects the concept of the law, which is no longer understandable through the pure reading of a text that expresses the normative power of a given legal system, if it does, because a symbolic, ritualistic, and organizational enforcing dimension is imputed into the concept of law itself. Law is even more than its symbolic representation and its ritual manifestation in procedural forms. It is also a smell, a gaze, tastes, and colors. Starting with such a multicolored picture of the law, the cross-cutting inputs or questions from linguistics can no longer be reduced to problems of interpretation, brilliantly demonstrated by Dietrich Bosse, for example, when understanding Recht als Text, or when Larry is interpreting a contract about, in between a president of the United States or somebody who represents him and a certain Stormy. Looking through the lens of legal disciplines, new questions will arise. How does linguistics contribute to seizing this multifaceted face of the law in order to grasp legal symbolism, ritualism, and organization? What kind of linguistics will be helpful for decoding such symbols, rituals, and organizational forms? And is there not a need for a fundamental epistemological debate? It's always necessary, but in a specific sense. How is the history of linguistics impregnated by the rise of legal history? Is our perception correct when attributing this kind of interaction primarily to the Grimm brothers, at least in Germany, who through their experience with Savigny's methodology in legal history came to found a German philology which reflected their conception of legal history? Take, for instance, the famous phrase von der Poesie im Recht in legal history. You know certainly this phrase. Es ist eine unbefriedigende Ansicht, welche in solchen Symbolen bloße leere Erfindung zum Beruf der gerichtlichen Form und Feierlichkeit erblickt. Im Gegenteil hat jedes derselben gewiss seine dunkle, heilige und historische Bedeutung. Mangelte diese, so würde der allgemeine Glaube daran und seine herkömmliche Verständlichkeit fehlen, or in English roughly said, it is an unsatisfactory view that catches sight of a merely empty invention in such symbols for the purpose of legal form solemnity. On the contrary, each of them certainly has a dark, holy, and historical significance. If these were lacking, the general belief in the matter and its conventional comprehensibility would be absent. what to do with such a phrase, and what's the role of juristic linguistics in this field to make this sense, this deeper meaning clear. But if not only the legal complex is shaped by social conditions and cultural traditions, what the Romanticists called Volksgeist, but language as langue in Saussure sense, stands in multiple relations to the formation of legal normativities. Then an abstract analysis of the two, so to say, deculturalized spheres of law and language seems to be highly problematic. It is then no wonder that the law and language debate necessarily had to be placed in its cultural context. No longer astonishing to us that this debate is led in different ways in Germany and France, in England and in the States and in Ireland. Nussbaumer warns in a bibliography on law and language, hier sei eine generelle Warnung angebracht bei der Lektüre der zahlreichen Untersuchungen aus dem angelsächsischen oder angelsächsisch geprägten Rechtsbereich ist stets in Erinnerung zu halten, dass der Strafprozess sich dort erheblich unterscheidet von kontinentaleuropäischen Strafprozessen. Or a general warning is appropriate here with the literature of numerous studies in the legal field that was influenced by Anglo-Saxonism. It must always be remembered that criminal proceedings here substantially differentiate themselves from the legal proceedings of continental Europe. He adds, und darüber hinaus ist bei Literatur aus unterschiedlichen Ländern generell mit teilweise recht erheblichen Differenzen zwischen Rechtskulturen zu rechnen. Furthermore, with literature from various countries, quite considerable differences between legal cultures are to be expected in some cases. To this I say indeed. But if the plurality of legal orders in a global world is one of the main challenges that the observation of law in the modern world demands of us, then the plurality of legal cultures is not a hindrance to understanding the legal world, but a necessary precondition. And we then need this all the more for comparing, reading, understanding, applying, and adopting legal cultures, as the series done by David Nelken had been called, together with the insight that linguistics can provide. A major part of our modest workshop today will concentrate on this task, if I got it right. Let me come to a second point regarding the undertaking of conceiving law as culture. It is the striking parallel and genetically complex intertwinement with the religious sphere. Taking account of law as being historically and systematically impregnated by the religious sphere, religious linguistics, see Jerome, Darkness, and Wim van den Bussche, for example, should be very useful for analyzing the complicated relationship between religion and law. Let's take a look at some monotheistic religions and how they relate the sacred to the law. See also Werner Gephart and Daniel Witte, here present also, The Sacred and the Law, the Durkheimian Legacy, that came out a year ago. In Judaism, religious duties are expressed in legal terms, and the hereby constituted community is expressed in legal and religious terms at the same time. A lot of explications and modifications of this overall thesis would be necessary, of course. Christianism is claimed to be free from ancient ritualism as to gain salvation by way of the law. It replaces law with universal love and the legal discourse with a kind of a religious discours amoureux. Islam represents yet another type of relationship. Central figures of the religious personnel are at the same time interpreters of the way to heaven as well as the path to inner worldly life. Sharia has this double meaning, and the ulama are the bearers of their knowledge culture. An added value of introducing linguistics into that debate is that it might offer a better understanding of what one could call the gliding scale of validity. From the observer's perspective on civil religion, Michel Foucault combined the role of the priest and the judge in Surveiller et Punir. But in his famous essay on Recht und Sprache, even Ernst Forsthoff is very clear by saying, in diesem Sinne bezeichnen Recht und Religion, die beide der Verkündigung teilhaftig sind, solche urtümlichen Ordnungszusammenhänge wie Recht und Religion. Der Priester und der Richter sind darum Urgestalten der volklichen Welt, die mit ihr als notwendig gegeben sind. This is a little bit embarrassing concerning the wording, but the content is something that has to do with the original cross-cutting proximity between law and religion. Whether the structural affinities between law and language may be reduced to what was later called a specific type of a speech act, here Verkündung als speech act. Very interesting to follow up this value. By bringing legal and religious linguistics into a conversational exchange, my hope would simply be that, besides the mythical and sacred aspects of language as such, according to Durkheim's saying, dans le principe tout est religieux, and if we may have a look back to the debate of Habermas and some of his critiques, to explain the normativity of acts by hinting to the illocutionary effects of speech acts, as proposed by Austin and John Searle. The question had been whether it is really the power of the wording and of the Lautgebärde, as we might say in German, as such, or some sacred grounds of language as such. So this is an interesting debate you might find in one of the books that we published together with John Searle. Some topics of this field might be the structure of religious semantics compared to legal semantics, rhetoric forms from a religious point of view, the evocation of preamble gods in modern constitutions. A lot of them are to be found in the Swiss constitution of the different Länder. International Law as a Belief System is the title of a book written by Jean d'Aspremont, Cambridge University Press, 2017, as Daniel Witte had told me. Religious pluralism and religious identities and legal pluralism, as well as linking linguistics and religious pluralism. Rogers Brubaker, for example, a great topic, I think, that falls absolutely in the center of the interest that we try to pursue in the Käte Hamburger, Kollegrecht als Kultur. To resume in a kind of deontic form, relate law to its brother sphere, religion, in all contexts, international law, local customs, religious law, family law, of course, by looking at the lingual traces of a sacred lost. So something that is really accompanying those who work with textual forms of normativity engraved in paper and in the form of statutes. Can law be thought of as, and this is my third point, as being exempt from processes of globalization, localization, and legal localization, and if so, how? Very few would dare to deny the challenge of the law in the global age by simultaneous processes of globalization and localization. We have touched it before. But what does this very banal constellation mean from a linguistic perspective? Several discourses which I have identified as followed are due to this background change in the realm of normativity. Legal translation, for example, your work then. Legal transplants, heavily opposed by Pierre Legrand. I tried to make an installation of this problematic by putting plants into just a luggage, and this is really the problem how to transplant plants. So in any case, I hope you understand the image. Global legal cultures, as Paul Schiff Berman called it, and their lingual expression, legal pluralisms in plurality. The question is then the following one: how may global linguistics help to avoid an epistemological trap to, on the one hand, be ashamed by Occidentalists who never get out of their conceptual skin, or be thrown back into the Separ-Whorf-like thesis of non-traductibility or context-boundedness of legal concepts on the other, as Legendre tends to claim. How can the Babylonian situation thus be transcended, and especially if there is nobody else able to speak the common language of... there is a Weber observing and a Union Jack fading away. It was the advertising for an exhibition I've done at King's College, and in the midst there is a projection of the process of making normativity at Brussels, and this was also not too much estimated by the Brexiters, if I have understood correctly. Creating a kind of Esperanto of the humanities, especially if English is no longer a common language because we have no native speaker anymore. We discussed the question before in Europe. So this is an idea I would like to discuss one day again, where IE, Japanese for house, solidarité sociale, French for solidarity, asabiya, meaning consensus in Arabic, compose a new cosmos of decentered vocabulary would be wonderful, very interesting for the sociological discourse. If it is valuable for the law, that's another question. I think images accompany words. Imago decidit, as Peter Goodrich had called it, or the power of emblems, as Valérie Ayer demonstrated a week ago during a wonderful talk at our center. To resume in normative language, think of normative orders as being in tension between localizing and globalizing tendencies, and be aware of its lingual mirrors. So this is a representation of the book we had done about speech act theory, constituting a specific understanding of constructing the world through legal categories. Whether global legal pluralism is feasible or not, the line of tension and conflict between legal cultures embedded in civilizational contexts deserves much more attention, to my understanding. Without predilecting the necessity of this conflict as a clash of legal civilization, but as a historically well-established indicator of the difference of worldviews affecting the normative projections and imaginations. So there could be a lot to be said about this point, but it will come, I think, later on, and I have to see to stick a little bit in time, and that's why I'm going a little bit faster, not without mentioning one of the main problems that will be touched in the next talk, namely the question how Juristenrecht and Volksrecht, this bridge, the gap between those different vocabularies and understandings of the legal world, how this can be made, and that it entails a germ of a fundamental divide within that community that we like to call legal community. The people's legal code and the jurist's legal code are different due to great tension in a multitude of legal cultures. Core TV shows have, according to an explanatory attempt I made some 20 years ago, if not the tool, then the latent function of simulating the understandability of a highly sophisticated and exclusive coding, thereby provoking harsh critique from legal professionals and the admiration of the ordinary public, as Barbara Salisch was able to prove in the more than 1,000 cases she handled in her show. have a look at the many faces of Barbara Salisch in the following picture. She's really a wonderful person. She's still interested in what we are doing here, but jurists in general are very critical with her because, of course, it is not sophisticated enough, etc. But we have a major problem there, and you will talk about that, how to bridge really this divide of understanding, getting and having an understanding of the legal complex in general, or at least to understand why it is not understandable. So this debate of understanding, not understanding, and of the law is an old one. It goes back to antiquity. As you know, we have wonderful articles about that. But to solve the problem in practice still, at least to my understanding, is an important element of bringing law and language in a productive tension. I come to the next point, and it's nearly the last one, that has to do with legal aesthetics. And this is, searching for legal aesthetics is more dangerous than looking for the law of aesthetics. It bears the double risk of sliding into legal kitsch on the one side, Grundrechtskitsch, as it was a provocative idea by one of our colleagues in Bonn, or into fascist aestheticism on the other, no less irritating, as Saul Friedlander has shown in Kitsch und Tod, der Widerschein des Faschismus. What insight could linguistics reveal regarding that field of tension? Perhaps only to explain, this is a representation of an image of justice that was made in Vienna's Belzane, and I thought there must be some gold for a mug that represents this image, otherwise it would not be kitschy enough. And the problem was that some months later, when having done it for an exhibition at King's College, I found in a description of the original that was burnt in 1945 that indeed there had been golden elements. So that's, for reception theory, a perhaps interesting point. Law and aesthetics, law and the art, and the role of language in that. You should know that we try to bring law and the arts together as law and music, law and architecture, law and literature, law and sculpture, law and film, law and comics, in order to go beyond the famous but sometimes also old-fashioned debate of law and literature. I have nothing against it. Nobody has, of course, against the reading of Shakespeare and Kafka, etc. But there is much more to say about law and the art. What is then the added value of bringing together the language of the law and the language of the arts would be my questioning in the law and language debate with law as culture. Analyzing the relationship between language and law can be fruitful from both a legal and a linguistic point of view, as modern law addresses its audience through linguistic form, and language refers to normative orders that do not always result in a state of orthodox orthography, Rechtschreibstaat, as Isensee had called it. For judicial work, one hopes that legal linguistics will provide clarification on the process of interpretation, with the risk of falling under hermeneutic universal suspicion. From a linguistic perspective, the fear of seeing oneself as subjected to the law's regulatory authority, which disregards the lively development of the law, is not unfounded, I would say. This tension should not just be negotiated abstractly, but rather discussed with outstanding representatives of legal linguistics. They're here, fortunately, and they will help us to understand this bigger and smaller problematics. I won't come back to them because they will talk themselves, and interpretations of others, of our talks. Der Gesetzgeber ist schon verärgert genug, wenn er sieht, dass er immer interpretiert wird, aber auch noch Sie. Das schenke ich mir an dieser Stelle. Let me finish instead my introduction with a provocative quote from Ernst Forsthoff, who brought law, culture and language into an unexpected relationship. I quote: Die Kultur deutschen Rechts ist dem Schicksal der deutschen Sprache unlösbar verbunden. The culture of German law is inextricably bound to the destiny of the German language. While the Rechtskultur Forsthoff was preaching about in 1940, this is the time when this article had been published, has been the non-culture of the law, eine Unkultur des Rechts. I cannot hide my hope for the critical power of linguistics to denounce the derivations of systems of injustice. The elimination of linguistic universalisms may be the foreplay to the elimination of people, and read living law as a law that praises individual and social life instead of suffocating it. Okay. Thank you very much for your attention.